This conference
situations
will
occurring
now be
here
recorded.
in Peoria. Yep, so we will be recording this just so everyone knows. And let's go ahead and get started. So a couple disclaimers that I need to get into before we get started. First, we have a non-discrimination policy. Prairie State Legal Services does not discriminate against any eligible person or organization in the provision of legal assistance on the grounds of race, color, national origin, ancestry, sex, sexual orientation, gender identity, age, religion, marital or family status, order of protection status, disability, HIV status, arrest record, political affiliation or belief, union affiliation, military status, unfavorable discharge from military service, veteran status, ex-offender status, limited English proficiency, or any other basis prohibited by law. And then finally, this presentation does not constitute legal advice or legal opinion on any matter discussed. This presentation is for educational purposes only. So as I said, I'm a staff attorney at Prairie State Legal Services, and we offer free legal assistance for low-income persons and for people for people age 60 or over who are experiencing serious civil legal problems and need legal assistance. Areas that we focus on include protection from abuse, preserving safe and healthy housing, obtaining and protecting income and benefits necessary for daily living, ensuring access to medical programs such as Medicaid, removing barriers to employment, and addressing other basic human needs. Of course, here today, we're here to focus on providing housing. So we'll move on to landlord-tenant basics. The first thing I'd like to discuss is just the written lease. I always recommend you should read the lease, preferably before you sign it. It's going to state everything that you need to know about the relationship that you're going to have with the landlord. If you fail to read it, there may be things in there that you weren't prepared for, and you may have agreed to things that you wouldn't have agreed to if you had read the lease. Some key aspects here include the amount of rent and when it's due, who's responsible for providing utilities and who's responsible for paying for them. And they should include every promise that the landlord has made. If there's been any sort of agreement that's been made outside of the lease, any sort of oral agreement, that needs to be inside the document, inside the lease agreement. If it's not, then it's going to be very difficult to enforce, and any judge is going to resort to what's written down as opposed to what you may believe was said by the landlord or by yourself. The written lease is going to include things that you've agreed to do. So that could include things like paying for rental insurance. It could include a pet policy, whether you're allowed to have a pet or not, or whether you have to pay some sort of deposit in order to have a pet. And it could include things about the condition of the apartment. It could include, you acknowledging that there are certain issues with the apartment that you're agreeing to live there anyway, regardless of some sort of issue that's going on with it. Before you sign a lease, before you agree to move in somewhere, you should make sure that you can afford the rent. You should make sure that you know and you trust that the people that you're going to be living with, because if there's any sort of issue with someone that you're living with, most landlords are not going to want to deal with evicting just one person from the unit. If they're going to go forward with an eviction, they're most likely going to try to evict everyone who's living there for any sort of violation if they're able to do so. You should know the landlord's name and contact information. If there's anything that's going wrong, you need to be able to get in touch with them. And I also recommend that you take photos and document the conditions when you move in. If there's something that's wrong with the apartment when you move in, something that's broken, something that's scratched up, you should have photos of that so that when you go to move out, they don't claim that that was something that you did. You have proof that the condition was the way it was when you moved in. You should, of course, pay your rent and you should get a receipt for all the money that's paid. It's very important to get receipts, because if the landlord claims that you haven't paid anything and you have, if you don't have a receipt, it's just going to be your word against theirs, and that's going to be a very difficult situation. So you should always get a receipt if that's possible. You should keep the utilities on if they're your responsibility. You shouldn't disturb other tenants. You should avoid any crimes that occur in the unit, and you shouldn't allow guests to do any illegal activity. And you should not allow anyone to live with you if they're not on the lease. If you have roommates, they have certain responsibilities as well. Anyone who's on the lease owes the full amount of rent. So if there's two people living somewhere and the rent is $1,000 a month, it's not that each one owes $500. You're both responsible for the full amount unless the lease says otherwise. You can ask for things like prorating or releases if someone moves out, but ultimately, if the lease says that you owe a certain amount, that's the amount that's owed. So because of that, you need to be careful about choosing who you have as a roommate. And if you have any agreement with your roommate to pay a certain portion of it, you should get that in writing. Tenants aren't the only ones with responsibilities. The landlord also has things that they need to do. They need to provide a safe and habitable unit. It needs to have working heat. It needs to have water available, and it needs to be free from pests and bugs. It needs to comply with the city or the town's housing code, which would include having working heat and water, but also other issues as well that the city code has listed down. And if there's any issues with that, you can call code enforcement. The landlord is not allowed to retaliate for calling code. And they should also make repairs in a reasonable amount of time once you make them aware of any repairs that are necessary. There are things that the landlord cannot do. They cannot change the locks, and they can't tamper with or turn off the utilities. That's true no matter what, even if they file an eviction notice with you, even if they get an eviction order until you move out, they cannot change the locks. They cannot shut off the utilities. They also are not allowed to make you pay for utilities for common areas or for other people's units. They cannot enter the unit unannounced unless they give you notice or there's some sort of emergency going on. And they're also not allowed to discriminate against tenants for any reason that's prohibited by law. If you get to the point where an eviction is being sought by the landlord, there are three main types of evictions here, and each one is going to require them to provide you with a notice. This is something that they have to deliver to you personally. It's not something that they can just tape to your door. If they're claiming that you haven't paid rent, then at that point they have to issue you a 5-day written notice with the amount listed that you owe. If you are in federally assisted housing, that is 30 days instead of 5. If they're seeking an eviction for some sort of lease violation that has nothing to do with failure to pay rent, at that point they have to issue a 10-day notice. So that sort of lease violation would include some sort of criminal activity, unauthorized occupants, or housekeeping issues. And then the final type of notice would be a 30-day notice. That occurs if your lease expires, but you continue renting from your landlord on a month-to-month tenancy, which I'll get into a little bit more later. If they aren't accepting rent and the landlord wishes to terminate the lease at the end of the term, then at that point they can also use this type of notice if you are what's called a holdover tenant, which means that you're staying after your lease has expired and the landlord is not accepting rent from you. If you don't move out after the notice period, at that point the landlord can file an eviction complaint in court. Once the eviction complaint is filed, you're going to have the opportunity as a tenant to appear in court and to contest the eviction. So the 5-day notice, like I said before, is for non-payment of rent. You do have the ability to cure a 5-day notice, which means that if you get this notice, and they're required to put on the 5-day notice the amount of money that they're saying is owed. And if during that 5 days you make full payment, then at that point the notice would be cured and they would not be allowed to file an eviction for that non-payment. They are required to accept full payment if they issue a 5-day notice during that time period. And if you try to attempt to pay and they don't accept it, then that's a possible defense, and we'll get into that a little bit later as well. 10-day notice for lease violations. This notice has to include the specific portion of the lease that they're saying is violated. The violation has to be material. It can't just be a small technical violation. It has to be a material breach. What constitutes a material breach would be up to the judge. It's not something that is always entirely predictable, but if it's something very small, like if they're saying there's damage to property and there's just a little scratch on the wall or something like that, that's likely not going to be considered a material violation. Unlike the 5-day notice, there is no ability to cure here. Once the violation has occurred and they issue the notice, they would be free to file the eviction if you have not moved out within those 10 days, even if you fix the problem that they're saying is occurring. 30-day notice, that's for a month-to-month lease. So if your lease is expired and the landlord still accepts money from you after that, what happens is the lease is considered to be month-to-month. So every month that you pay, the terms of the lease extend another month. And at any point, the landlord can decide that they don't wish to do that anymore. And at that point, they would be able to issue a 30-day notice. It has to follow the lease term, though. So that means that, for example, today is December 20th. So if today a landlord were to decide that they didn't want to continue renting to a tenant anymore, but that tenant's rent is due on the 1st of the month, they cannot issue a 30-day notice saying that you have to be out by January 20th. You would have to be out, the notice would have to give you until at least February 1st at that point, because it has to cover an entire period of rent. You should also make sure to read your lease and make sure that the lease, whether it automatically renews. Some leases will do that if you don't affirmatively tell the landlord ahead of time that you don't wish to renew. Once a 30-day notice is issued, there's generally not a defense available to this. Other than rare circumstances, if they file a 30-day notice, they will be able to get an eviction order at some point if you don't move out at the end of the notice period. So we recommend that you get advice early. As soon as you get a notice, or if you're aware that you're going to be getting a notice soon, you should get some advice, call an attorney, call Prairie State if you're eligible, and you may be able to avoid getting an eviction case filed against you, whether that be because of some sort of defense or through an agreement with the landlord. So there are multiple defenses that could be available if an eviction is filed against you. One could be for improper service, or the notice is incorrect. So like I said before, a 5-day notice has to have the amount of money that's owed. The 10-day notice has to have the specific portion of the lease that was violated. So that would be an incorrect notice if they didn't include that, and that could possibly be a defense. There could also be a defense for the improper filing or improper service of the complaint. Of course, there's a defense if they're saying that rent is due and you don't believe that rent is due if you've made payment. There could also be a defense if during the 5-day notice period, rent was either accepted or tendered. And tendered means that you attempted to pay rent during the 5-day notice period, but the landlord refused to accept it. There could be a defense if the eviction is retaliatory or if it's based on a protected class. Retaliation could include, like I said before, if you were to call code enforcement and report some sort of violation, they can't retaliate and file an eviction for that sole purpose. Habitability issues can reduce the damages, they can reduce the amount of money owed. So if there are issues with the apartment that have caused you to get reduced value out of the unit that you're living in, it's possible that a judge could decide to reduce the amount of money that you should have been paying per month. The issue there is that if they do reduce the amount that they're saying is owed, but the judge says after taking that into account that you still owe anything, an eviction can still go through even if they determine that you're only $1 behind on rent. Waiver is another possible defense. So if they were to issue, for example, a 10-day notice in December, and then in January they accept rent from you, it is possible that that could be viewed as them waiving the right to the eviction without issuing a new notice because they've accepted rent and they've continued the landlord-tenant relationship. So we have a courthouse eviction project here at Prairie State. We are generally present at both Peoria and Tazewell Eviction Court, and we're prepared to take people who are at court, who are facing eviction and qualify for our services, even if they haven't previously spoken to our office. So once you get complaint is filed against you, you'll get a summons to appear in court for what's called the first return. And at that point, if you haven't already called Prairie State, once you arrive at court, you can apply for our services there. We can't guarantee that we would be able to represent you at that time, but we would be there in most cases and able to at least take an application from you. At that point, you can also apply for rental assistance through projects such as the court-based rental assistance program, which is run through the state. You would also speak to the judge at that point. If Prairie State is representing you, then we would take care of that for you. But if not, some options once you're at the first appearance would be to either come up with an agreement with the landlord to admit that the eviction notice was valid and that you're agreeing to move out at a certain date, which would depend on what the judge is recommending at that point, or you can set the eviction case for a trial. In Peoria, generally, if you request a bench trial, the trials are set the next week. Once the first return is over with, at that point, either you've reached an agreement or there's a trial date where the case has been continued out. If there's a trial date, then you should be gathering evidence and proof to support any sort of defenses that you may have, whether that be receipts or witnesses or photos of anything that the landlord is claiming is the basis for the eviction. And if the landlord has indicated that they would be willing to accept rental assistance, you should also be applying for that and pursuing that assistance money. By the time the trial date comes around, which I said before would be about a week later, you would either need to have come up with an agreement to either have a move-out date that's set or for some sort of agreement to pay rent on top of your ongoing rent to make up for any non-payment issues that have occurred. Or you can go to trial on it at that point and tell the judge about any defenses that you may have. Generally at the point where it's at trial though, if you are behind on rent or if there has been some sort of lease violation, it's likely that an eviction order would be entered. If you're looking to apply for services from Prairie State, we would recommend that you call this toll-free number or go to evictionhelpillinois.org. We also have a phone number for fair issues, which we didn't get into today, but that would be something having to do with discrimination. And then if you call the Peoria office, this is my name and contact information. I'll go ahead and leave this up. And then if anyone has any questions, I can take questions at this point. Okay, so I've got one question. I also see that we may be having some tech issues. But one question I see is how far back does the background check go when landlords request a background check, and what options are available to help if you have things on your records that you're worried about? I'm not sure how far back the background checks go. That may depend on the service that they're using. But if you are worried about things on your record, Prairie State does do criminal record sealing and expungement. I would recommend that you call our office and see if that's something that would be available for you. I don't know if there's any other questions or if people can hear me or not. I do see that there's some people are saying they can't hear anything. Nicole, am I showing up?
Yep, you're showing up. Okay.
Okay,
I think it's
great.
an isolated issue. We'll post
All
the
right.
recording for everyone.
All right. Well, I can stick around, and if there's any questions, I can answer them. But it appears that we've just got the one so far. Okay, well, it seems like we're not going to be getting many questions here. So if anyone thinks of any questions, feel free to reach out to Prairie State. Thank you all for coming out and listening to this, and have a great day.